Motion.
Thank you, Mr. Chairman.
It's all yours. Yes, sir. Which one are you doing first?
1612.
All right.
Okay, thank you. Mr. Chairman, Site Selection Magazine for May 2016 identified North Carolina as the second best state in the United States to locate a business. Virginia was identified as number 6 under Governor McAuliffe. CEO Magazine rated North Carolina the third best state to do business in 2016. Virginia was ranked number 12. North Carolina has a $425 million surplus in the previous year ending June 30th, and a surplus of $191 million in the first third of the current fiscal year, starting July 1st. They were ranked number 2 for doing business by Forbes recently. Virginia, under our governor, who has expressed various concerns with sexuality, was ranked number 6. In November 2013, when he was elected, we were number 1. Clearly, the facts. And as respect to surpluses, practices of separation of the sexes in locker rooms, showers, bathrooms, is doing the same bad old laws of sex-segregated facilities with respect to the use of locker rooms, showers, bathrooms, and changing areas. In fact, they did this in the wicked city of Houston, whose citizens, by referendum, overwhelmingly rejected an effort by the leaders of that city to add sexual orientation and gender identity to the status of protected classes. It is rank hypocrisy for North Carolina to threaten NCAA to threaten North Carolina with the removal of championship basketball games when Texas had the same law. In fact, they were worse because the people did it, not just their leaders. And let me tell you this. If North Carolina threatens a boycott because we're even considering this, or it might pass, for simply affirming the status quo, right now, no male may go into a girl's locker room to take showers with a girl in high school. You cannot go into changing areas. You cannot stop on the rest stops to do the same thing. If the NCAA threatens Virginia, I will write Attorney General Sessions and ask that Attorney General look at the Sherman Antitrust Act status of the NCAA pursuant to a 9th Federal Circuit Court of Appeals decision, which concluded that the National Collegiate Athletic Association was indeed subject to the Sherman Antitrust Act. Now, in October 2016, when CoStar Group chose to locate a 730-job project in Richmond because of the alleged hostile attitude in North Carolina, it should be remembered first that CoStar was offered about $1 million more in incentive money by Governor McAuliffe to come to Richmond, and that Virginia's current law with respect to biological males not being able to use facilities for showers, locker rooms, changing areas, and bathrooms of the opposite sex are identical to North Carolina. If this is a boycott, we need to have other people who are captains of industry. When PayPal announced in March 2016 that it was not going to take $3.6 million, which they had previously agreed to take to relocate in Charlotte, North Carolina at that time had sex-separated facilities, as they still do. Furthermore, PayPal operates in 25 countries where homosexual acts are treated as serious crimes, and sometimes homosexual persons are executed. PayPal, if you're really serious, if you want us to respect you, move out of those 26 countries. Then you want to talk about Deutsche Bank. In April 2016, Deutsche Bank froze its plan to expand an office in North Carolina after the passage of their law affirming sex-separated facilities. How lucky for North Carolina. I say that because Deutsche Bank in August 2016 was subject to a $2.5 billion fine levied by the Financial Industry Regulatory Authority in the United States for broadcasting private information about investors to their employees. That's unethical conduct. They got fined. The claim, moreover, that we do not consider legislation when court cases is pending is bogus. No one here in my 25 years has ever searched the dockets of Virginia circuit courts to see if there are constitutional challenges to existing laws before drawing up legislation. Second, we will consider this year restrictions on police-operated license plate readers, while the ACLU has a case on appeal out of Fairfax County to the Virginia Supreme Court. Thirdly, the General Assembly has passed laws dealing with constitutional challenges. We pass laws that are declaratory of existing law. What that means is that we don't care if there's a constitutional challenge. We're telling the court, you will understand the law in the way that the General Assembly tells you. Now, is this just done arbitrarily a long time ago? Before anybody gets too deep in a hole and saying we shouldn't do this, let me remind you that we did this on March 23rd, 2015, with respect to search warrants. This is a criminal case for computers, computer networks, and other electronic devices. Now, was this radical idea passed on a one-vote margin in each house, a finger-gripping close vote? Well, it was really close in the House, Mr. Chairman, 99-0. In the Senate, it was 38-0. Let me give you another one. This is from even closer. This is 2016, February 12th, 2016. Another bill that we passed, which was declaratory of existing law. You know what that passed by in the House? A mere 96-0. It was unanimous in the Senate. So the claim that we don't deal with this, if there's cases pending, is erroneous. Passing a statute of declaratory law is the legislature's way of telling the court we don't like how you have made decisions. How would you, if you were a loving dad, react if you saw a grown man follow your 9-year-old daughter into a bathroom at a state park? Would parents want their 14-year-old daughters on the school swim team taking showers with 17-year-old biological males in public school locker rooms? Would women feel safe at an interstate rest stop knowing that biological males could use the women's bathroom? How could a woman distinguish between a transgender individual who means no harm from a male who does intend harm? It is because of concerns like this that when more than 600 parents and students in Prince William County, and many more in Fairfax and other areas of Virginia, but I attended meetings in Prince William, attended meetings to oppose changes in the school policies which would have allowed biological males to use dressing rooms, locker rooms, showers, and bathrooms set aside for females, that I decided I would do something. In response to that outpouring for the safety and privacy of our children, I introduced 1612 to simply preserve the status quo to prevent schools and government entities from changing policies which protect the privacy in facilities normally. Why should we enact this? 2 reasons. Number one, the Obama administration last year issued a guidance letter in distinct violation of Title X law and Title X regulations, which specifically provide, which have been upheld in at least 2 federal courts that I know of, that separation of the sexes in bathrooms, changing areas, and like facilities and showers is not illegal sex discrimination under Title IX. It's all we're doing is preserving the status quo, but it's necessary specifically in Virginia because Mr. Herring has issued an opinion last year to Senator Evan in Fairfax that local school boards may add protected classes to their employment and student policies which have not been authorized by the General Assembly. His conclusions are at variance with at least 6 attorneys general, 3 Democrats and 3 Republicans, who have stated that only the General Assembly is authorized to enact such laws and has refused to do so on more than 20 occasions. In Virginia, jurisdictions such as Fairfax, Prince William, Stafford, and Loudoun school board members have pointed to Mr. Herring's novel claims to add provisions relating to gender identity and sexual orientation to their policies. In each of these jurisdictions, language was offered which would have permitted biological males to use locker rooms, changing clothes, and taking showers with females, as well as multi-stall bathrooms previously for use only by females. Federal courts agree that the separation of sexes for bathrooms, dressing rooms, locker rooms, and showers is not sex discrimination. In 2009, a case, Federal Court of Appeals, Castile versus Maricopa County Community College District, rejected the claim of a man who identified as transgender and prohibited him from using the women's room for safety reasons. In 2015, a Pennsylvania Federal Court of Appeals, Johnston versus University of Pennsylvania, found that, quote, A university's policy of requiring students to use sex-specific bathrooms and locker facilities based on the student's natal or birth sex rather than their gender identity does not violate Title IX's prohibition of sex discrimination.
Delegate Marshall?
Yes, sir.
We're going to have to kind of, I know you have a number of folks to speak here as well. We have a very heavy docket and need to be finished up by 4 o'clock. So if we could.
Well, let me offer an amendment to my bill.
Okay.
Make a suggestion. On line 31, it currently states, sex means the physical condition of being male or female as shown on an individual's original birth certificate. Strike the word original. I would ask that that amendment be offered and voted on.
We have a motion and properly seconded on the amendment. All in favor say aye. Aye. Opposed, same sign. Okay. This bill is before us. Delegate Marshall.
Title IX, or rather the change that would be affected by such delineation to allow people to self-identify as someone of the opposite sex, is going to have effects for sports, and women's sports in particular.
Okay. Thank you, Delegate
Thank
Marshall.
you.
Do we have any questions from the committee at this time? All right, I know we have a number of folks to speak today, and if you weren't here when we opened up the committee meeting, I asked that, if you could have one person possibly speak for the group. And then if someone that's here that has any additional information, they can bring that forward, but we have a very heavy docket today. So anyone here speak for the bill?
Thank you, Mr. Chairman. My name is Diana Shores, and I'm here speaking on behalf of the Virginia First Foundation. I would like to begin my remarks by reminding all of you that the Virginia Constitution, Article 1, Section 11, provides the following. It says, the mere separation of the sexes shall not be considered discrimination. I say this as I begin to talk to you about student access to opposite sex changing areas and how they could be subject to schools facing, obviously, tort liability. Not only should school districts prevent students from accessing opposite-sex restrooms and locker rooms, school districts should do so to avoid violating the rights of the students. Students have the fundamental right to bodily privacy. That right is violated when students, including kindergartners as young as 5 years old, are forced into situations where members of the opposite sex may view their partially or fully clothed, unclothed bodies. As the Ninth Circuit Court has already recognized, shielding one's unclothed figure from the view of strangers, particularly strangers of the opposite sex, is impelled by elementary self-respect and personal dignity. Forcing students into vulnerable interactions with the opposite sex in secluded restrooms and locker rooms would violate this basic right. Courts have found that even prisoners have the right to use restrooms and changing areas without regular exposure to viewers of the opposite sex. A case found that a prison violated a prisoner's rights to bodily privacy by forcing them to use a dormitory and a bathroom facility regularly viewable by guards of the opposite sex. Courts have found that a constitutional violation where guards regularly watch inmates of the opposite sex who are engaged in personal activities such as undressing or using toilet facilities or showering are problematic. Students possess far more robust legal protections and are obviously entitled to greater privacy rights than prisoners, are they not? There will be some who attempt to provoke public outrage by asking the question, where do I, as a transgender, go to the bathroom? This bill addresses this by providing appropriate accommodations in the schools. These are accommodations that are already being addressed in schools for various academic issues. This is no different. By alerting the parents, we are ensuring that parents have the right to understanding and knowing what's going on with their child in the schools. Your very own House and Senate page programs prohibits boys and girls from commingling in their dorm rooms in the evenings. This is a common sense bill that accommodates everyone and provides privacy for all of Virginia's children. Let's not kick the can down the road hoping that someone else will solve this problem. Let's address this today. Let's vote yes on this bill and get it out of committee and get it to the floor for a vote. Thank you.
Thank you. All right, thank you. Yes, ma'am.
Hi, Mr. Chairman. My name is Jeannie Everhart, and I'm a mother of 4 children and 2 grandchildren. This is a problem that is here right now. It's not a can that can get kicked down the road. We're already in the midst of this problem. Just a short story. We went to dinner with some friends in the Lynchburg area the other day, and they sent their 10-year-old daughter into the restroom, into the women's restroom, and there was a man in that restroom washing his hands. She didn't know what to do. She went into the stall and locked the door and was traumatized. As a 10-year-old little girl, she did not know what to do. When she came back to the table, once the man, if it was a man, I'm not sure, she explained it to her mother why she was so flustered. I'm even flustered trying to even tell this story. The next time she goes into her restroom, she's been instructed to turn around and leave if there's someone there that looks like they're the opposite sex. I know it is a problem when a woman biologically looks like a man, and where do you tell them to go to the bathroom? Little children and women should not be traumatized because they're not sure where to go, but we need to address this issue. Gathering my thoughts.
Thank you, but we
I understand. One
very
last
brief.
thing.
We're-
Let me close.
yeah,
Let me
we're-
close.
Thank you.
Let me close with the mother's heart here. I'm looking at everybody on this board, and your fathers, your grandfathers, your mothers, your aunts, your sisters, and all of you have little girls in your family. You have women in your family. And you picture it being your child walking into that restroom and being traumatized. I have children. I have grandchildren. And so I just urge you, with everything within me as a mother, to pass this bill, HB 1612.
Thank you. Thank you. We need to start speeding it up, folks. I would
Thank
really
you, Mr.
appreciate
Chairman.
that.
I promise very briefly. My name is Krista Duckworth, and I'm here representing our group from Culpeper, Virginia. I would just like to say, as a mother of small children, I support this legislation, and I don't think it's appropriate to force my children into a situation at a public school where her only option for showering facilities would be effectively co-ed. Thank you for your time.
Thank you. Sir.
Mr. Chairman, members of the committee, Jeff Caruso with the Virginia Catholic Conference. I will be very brief. Our primary perspective is that parents should have the primary seat at the table in these discussions. As so many parents have expressed when this issue has been raised in local contexts, the current and long-standing practices maintained by schools throughout Virginia appropriately respect the dignity of all. As the debate continues, and it will continue well beyond today, we must not leave parents behind. They need to be the primary participants in this dialogue, and their views must be respected. Thank you.
Thank you. Yes, sir.
Mr. Chairman, members of the committee, my name is Josh Hetzler with the Family Foundation. I just want you to know that the majority of Virginians are very much in favor of this policy. I don't know if you saw recently this week, a Mason-Dixon poll came out, and only 1/3 of Virginians are actually in favor of the idea of a person who identifies as another sex would be able to use the facilities consistent therewith. And I just finally want to draw your attention to something that Delegate Marshall already mentioned. And when we consider what has already happened in this past year with several school boards across the state, in particular 3, Loudoun, Prince William, and Fairfax, we saw an overwhelming outpouring of parents showing up concerned. I know I was there. I saw it with my own eyes, hundreds and hundreds of parents. So there's a lot of support for this bill. I hope you'll consider that, and I hope you'll support it. Thank you.
Thank you. All right. Anyone in opposition to the bill?
Mr. Chairman, Claire Guthrie Gusting, I'm on behalf of the ACLU of Virginia. I wanted to start my good friend Delegate Marshall threw so many red herrings out here that I thought maybe I'd start by throwing a few back. And, this is not about what happened in North Carolina or any other state. Two, the Sherman Antitrust Act applies to price fixing, and yes, the NCAA has been held to account for tuition issues related to fixing prices and things like that, but the idea that any private organization that engages in a boycott under the First Amendment would be subject to any kind of antitrust action is a little bit beyond the pale in terms of the suggestion. Three, the law of this circuit right now, not the Ninth Circuit in California or some other circuit, but the law in the Fourth Circuit right now is that Title IX does, in fact, impose on all of our local school divisions and education programs that receive federal financial assistance an affirmative obligation to protect students from sex discrimination, including transgender students. And we're litigating that case in the Supreme Court. I mean, yes, it was appealed by the school division, and yes, it's pending in the Supreme Court, probably to be argued in March. But the law of the Fourth Circuit right now, applicable to all these school divisions you've heard about, is that Title IX requires them to protect all of their students, including transgender students, from discrimination while in school. Second, the other red herring is that somehow local school divisions and local governments are the same when it comes to the Dillon rule, and that's just not right. Local school divisions under our Virginia Constitution have the obligation to run the day-to-day operations of the schools, and they have a very different relationship with the Commonwealth than local governments do, which are statutory subsidiaries of the sovereign. And so it is not the case that anything that the General Assembly has specifically said would bar a local school division from doing something that's really important, which is complying with federal law and affording their employees and students the protection of the federal Constitution, which they as elected officials take an oath to uphold.
Thank you.
Bottom line, this
You have
bill...
a very long line.
I know.
We're not
Bottom
halfway
line,
through the
this-
document. We have to be finished by 4 o'clock.
Bottom line, this is billed as a privacy protection bill. It is not. And in fact, it violates the privacy of any number of people. And if you look at the waiver of sovereign immunity and the lawsuits that you are setting your governmental entities up for, anybody who sees somebody that they believe is not in the right bathroom can sue the government entity under this bill and claim that they suffered emotional harm, even if it turns out that that person was in fact the gender associated and the biological gender associated with the bathroom, which is Delegate Marshall's intent. So thank you very much for your attention, and I know there are other people.
With everyone. Next, please.
Thank you, Mr. Chairman. My name is Theodore Kahn. I'm a private citizen. I've lived in Virginia my entire life, all 32 years of it. This bill directly affects me because I'm a transgender man. Currently, I use the men's room where I just go to the bathroom. That's it. There's nothing else to do in the bathroom other than go to the bathroom behind a stall. That's it. Nobody is seeing you. It's private. For the physical privacy that this act pretends to protect, my privacy is already protected. If this bill were to pass, it would make it illegal for me to go to the bathroom. It would make it so that I'm forced to use the women's room. Can you imagine me in the women's room? That would have the police called on me. I don't understand why Delegate Marshall seems to think that I'm supposed to use the women's room. Please don't make my state discriminate against me.
Well, thank you. We have maybe 2 minutes or so. We need to wrap this up, don't we?
I'll be brief. My name's Amy Adams, and I'm the mother of 3, one of which is a beautiful, brave, transgender girl. She's 12 years old, and she's in middle school. And she deserves to be protected just as much as every single person in this room, just as much as every one of your children do. So please oppose this bill.
Thank you.
Thank you.
Mr. Chairman, James Parrish, Equality Virginia, we vigorously oppose this bill. It does nothing short than stigmatize and harm the transgender individuals in Virginia and those visiting the Commonwealth.
Thank you. Do you have any further stuff, Dr. Mark? Do you have any additional information, or you just want to speak your with, if you don't mind?
Hi, I'm Maria George. I'm with AIA Virginia, Society of the American Institute of Architects, and we oppose this bill on the grounds that it violates our public policy on diversity, equity, and inclusion.
Thank you.
Mr. Chairman, the Cyber Education Association continue to oppose this bill and the addition of the principal notification requirement.
Thank you. All right, Delegate Marshall, we need to, very quickly.
Mr. Chairman, first of all, courts don't make law, they decide cases. In congressional debate on Title IX, a question was specifically asked, could a guy use Title IX to get into a girl's locker room? The answer by the proponent of this was no. Title IX regulations say you can't do this. Right now, here, transgender female MMA gives fighter opponent concussion. Knockout. Transgender man people videotaping women.
We have, we're on one bill, you still have another one. So we need to
Let me just say this.
really wrap this up.
State ACLU leader, ACLU quits, daughters are visibly frightened by guys using the women's bathroom.
Thank you. Any additional questions from the committee? Delegate Knight.
Move late bill on the table.
Second.
We have a motion which is non-debatable.
Can we please put this on a record vote so the Virginians know just what you're doing down here? You campaign one way and come down here and kill things silently. I think that's
Delegate Marshall,
Yes, sir.
please wait. Wait, we have a motion on the table, properly seconded. All in favor, say aye.
Aye.
Opposed, same sign. Like, one no. Delegate Marshall, we have one more bill. We need to be very brief. We're halfway, not even halfway through the document.
Justice demands that you give appropriate time to this, not speed this, through here.
We have a very heavy agenda today, Delegate Marshall.